Everyone, to the third of three sessions on the rule of law and combating systemic discrimination. I am Professor Errol Mendes, the president of the International Commission of Jurists Canada. Established in 1958 by the legendary Chief Justice of Canada, Ivan Rand, and other leading judges, lawyers, academics, and human rights champions, at ICJ Canada, then and today, we seek to promote greater understanding in Canadian society on the rule of law, human rights, and non-discrimination in the operation of our laws and institutions. Given the challenges to the rule of law we have seen, not only in other democratic countries, but also in our own society, you will admit it is a worthy goal for an organization to focus on. We encourage the participants today to join us in this endeavor and become active members of ICJ Canada. I encourage you and those in your networks to check out what we do in promoting the rule of law at our website, www.icjcanada.org. And for those of you who are not already members, it is very easy to join online. Today, we are focusing on corrections, which follows the first of the three sessions, which focused on policing, which took place on April the 9th, and the second one focusing on judicial proceedings, which took place on April the 29th. Today we have registrants from across Canada and maybe some even internationally. And for all three sessions, we have recordings which will be made available for those who are interested, and especially for those who are present and future members of Canada, we encourage you to distribute the recordings of these three sessions. Before I introduce the moderator for the panel today, my good friend and colleague, Monette Maillet, and our executive director, David Hebb, I want to give you a land acknowledgement for this virtual meeting. I begin by acknowledging the Indigenous peoples of all the lands that we, who are meeting online from across Canada, are on today. I would like to acknowledge that the land on which I and several of the participants on the panel today are speaking from the traditional and unceded territory of the Algonquin Nation. While we meet today on a virtual platform, I would like to take a moment to acknowledge the importance of the lands which all participants in today's event each calls home. We do this to reaffirm our commitment and responsibility in improving relationships between nations and also to improving our own understanding of local Indigenous peoples and their cultures. From coast to coast to coast, we acknowledge that the ancestral and unceded territory of all the Inuit, Métis, and First Nations people that call this land home. Please join me in a moment of reflection to acknowledge the harms and mistakes of the past and to consider how we are and can, each in our own way, try to move forward in a spirit of reconciliation and collaboration. Now, briefly, for the introduction of the moderator for the panel, and today, also our executive director, who is actually the tech genius behind this event. Monette is a moderator for this panel. She is the vice president of the International Commission of Jurists Canada and is a well-known leader who has a passion for human rights and social justice issues. In October 2020, Monette joined the Office of the Correctional Investigator as Executive Director and General Counsel. This office is responsible for addressing complaints from individuals who are serving federal sentences against the Correctional Service of Canada and investigating and reporting on individual and systemic issues. Prior to joining the OCI, she worked at the Canadian Human Rights Commission for 20 years and in various positions in the Commission as litigator, as well as a variety of management positions and ending her career there as Deputy Executive Director and Senior General Counsel. She received her undergraduate in criminology from the University of New Brunswick and a Bachelor of Laws degree from Dalhousie University. She was called to the Alberta Bar in 1991. David Hebb, our Executive Director, is an accomplished young lawyer who completed his professional legal qualifications working at the Military Police Complaints Commission. He's a graduate of the law faculty at the University of Ottawa and is completing a master's degree in law. He has also been a legal advisor to various members in the Parliament of Canada. Over to you, Monette, to start this session.
Thank you very much, Errol. Well, good afternoon, everyone. My name is Monette Maillet, and I want to welcome you to ICJ Canada's last of a three-part series on the rule of law and combating systemic discrimination in the criminal justice system. During this afternoon's program, we will begin by hearing some introductory remarks from our distinguished panelists, about 10 to 15 minutes each. This will then be followed by a free-flowing discussion of about 30 minutes amongst the panelists. We will leave the last 25 to 30 minutes for questions from the audience. You'll note that there is a Q&A function that has been activated. As you think of your question, please type it in the Q&A box. Also, kindly indicate if your question is addressed to one panelist in particular or is a question for all panelists. Before we begin, I'd like to briefly introduce you to our panelists in the order that they will be speaking. The bios that I will present to you today are brief, and you can find more complete bios of our panelists on the ICJ website under the News tab, and scroll down to this event and you'll find them there. So I'll begin by introducing you to Dr. Ivan Zinger. Dr. Zinger is the correctional investigator of Canada and a renowned expert in domestic and international human rights law in prison settings. His opinions are frequently sought out by the media, parliamentary committees, and advocacy organizations. He does not shy away from speaking truth to power, and as Canada's federal prison ombuds, he brings national attention to breaches of human rights and dignity in our federal prisons. His academic publications are significant and include articles on a variety of subjects, including prison oversight, ethics, dangerous offenders, correctional treatment, the diagnosis of psychopathy, conditional release, penal segregation, and the impact of tough on crime measures on corrections. He's also my boss. Next, I'd like to introduce you to Patricia Whyte. Patricia is a peer support worker with the Elizabeth Fry Society of Mainland Nova Scotia, which means she is a mentor and a peer support for women in their GATE program, which stands for Girls Against Trafficking and Exploitation. Patricia spent 4 years in federal prison and took her release at Holly House in Dartmouth, Nova Scotia. She is passionate about acknowledging the truth about life in prison, as well as in social justice issues in general. Through the Elizabeth Fry Society, she's been able to turn that passion into a career. Next, I want to introduce you to Tom Cardoso. Tom is an investigative reporter with the Globe and Mail. And we're delighted to let you know, just last week, it was announced that he was named Canada's Journalist of the Year from the National Newspaper Awards. We're so lucky because this award is for an investigation he conducted, resulting in the publishing of a piece in October 2020 called Bias Behind Bars, which is a groundbreaking, years in the making investigation on racial bias in Canada's prisons. And we're lucky because he will talk to us about that today. As part of investigating this piece, he used data obtained through an access to information request. And he conducted an analysis of 50,000 federal inmates' risk assessment scores and has since interviewed close to 100 inmates, academics, lawyers, politicians, and correctional experts. And last but not least, I'd like to introduce you to Senator Kim Pate. She was appointed to the Senate of Canada on November 10th, 2016. Kim is a nationally renowned advocate who has spent the last 40 years working in and around the legal and penal systems of Canada, with and on behalf of some of the most marginalized, victimized, criminalized, and institutionalized, particularly imprisoned youth, men and women. Senator Pate was the executive director of the Canadian Association of Elizabeth Fry Societies from January 1992 until her appointment to the Senate in November 2016. She has developed and taught prison law, human rights, and social justice, and defending battered women on trial courses at law faculties in this country. Senator Pate is a member of the Order of Canada, a recipient of the Governor General's Award in commemoration of the Persons Case, the Canadian Bar Association's Bertha Wilson Touchstone Award, as well as 6 honorary doctorates from universities across the country. So I'm really excited about the panel and the panelists here today. They're just incredible. And before turning it over to Ivan, I want to provide a bit of context for this webinar in particular. As Errol mentioned, this is the last of a 3-part series on discrimination in the criminal justice system. The first was on discrimination in policing, and the second on discrimination in judicial proceedings. They showed us that we all have implicit and unconscious biases. Some biases may even be explicit and conscious. And how important it is that we all be aware of these biases to try to prevent discrimination from happening. We have also seen that all organizations and agencies may well have policies, practices, and decision-making processes that are part of the structures of an organization and which create or perpetuate discrimination, disadvantage for a targeted group. That is what systemic discrimination is. In the context of the criminal justice system, we have seen how individuals, as well as the system itself, operates in a discriminatory manner which has negative impacts on people, particularly racialized people. Those who have had contact with the police, as well as when they go through the court process, are examples of what this discrimination can look like. Today's webinar takes us on the next leg of that journey of the criminal justice system as to what happens to people once they are sentenced and incarcerated, and how the correctional system works well for different groups of people. We will learn about what is the prison experience and does it do what it's supposed to do, which is to protect the public while also ensuring that people are rehabilitated in accordance with standards of dignity and human rights. So with that, I'd like to pass it on to Dr. Ivan Zinger for his opening remarks.
Well, thank you very much, Monette and Errol, for the kind invitation and great welcome. I thought today I would probably start with just a general statement about Canada in general. I think that domestically, I think we benefit as Canadians, domestically, but also internationally, for a very good reputation on human rights, and we are seen as a multicultural society that functions well, that we're inclusive, that we have good diversity, and we tend to have high credibility in other jurisdictions in terms of our promotion and compliance with our human rights. So I thought that it would be start with a positive note and see whether that reputation is really truly deserved. And I think if we looked at corrections, it may at least highlight some of the struggles that Canada is facing. I like this idea of looking at discrimination in corrections. We know that discrimination exists in society at large, and that those that are discriminated often end up having contact with the criminal justice system. The criminal justice system is aware of some of the systemic barriers. We do have courts for mental health. We do have courts for addiction issues. We have, things that are more tailored to Indigenous people, like sentencing circles and things of that nature. But I think the courts, the police are struggling. And I think no one in their right mind in charge of those institutions could, deny that there is an issue with systemic discrimination. And so the question is, with respect to correction, how do we fare? And is the systemic issues, do they continue and are perpetuate throughout corrections? So that's the question I'd like to answer. So the first place that I looked at was we do have anti-discrimination law at the federal level. That's the Human Rights Act, the Canadian Human Rights Act. And they're listed in there 13 different grounds for discrimination. And I have to say, when I reread them, I think easily 10 or 11 come right up to mind that there's been issues in the federal correctional system where these things were at play. So, things like race, ethnic origin, color, religion, age, sex, sexual orientation, gender identity, issues around disability, including mental health, I think all were subject to, to complaints to the Canadian Rights Commission, to tribunal decisions by the Human Rights Tribunal or by courts. And that brings me to sort of looking at, a famous quote from Fyodor Dostoevsky, who I think was the first one to be credited the statement: "The degree of civility in a society can be judged by entering its prison." So if you are subject to discrimination while you're in prison, I think there is a big issue, and that is, sort of telling in terms of the values and some of the struggles that we have in Canadian society at large. So the treatment is definitely important, but beyond the treatment, we also have to look at who are the men and women who are incarcerated in our penitentiaries, our 43 penitentiaries, by the way. With respect to who they are, based on some of the those grounds of discrimination, are those things at play? Are some groups overrepresented, or are some groups struggling with some issues to have their rights enforced? So I thought I would basically look at some of those systemic areas by looking at the profile of the offender population, as if you want, to gauge the success or failure of some of our broad public policies. So it can be used, that profile, as a barometer for gauging these things. And I think that is quite telling. So let me start a little bit by telling you who those women and men who are incarcerated in federal corrections, who are they? So the first area that I would like to talk to you is about disability, about mental health. And there's definitely a very high prevalence of people suffering from serious mental health issues in federal corrections. We know that about 73% of federally sentenced men and about 80% of the women meet the criteria for a current mental disorder. We also know that upon admission to federal corrections, that about 30% of people coming in are in need of psychological or psychiatric services. We also know that there's an inordinate number of prisoners who are on psychotropic drugs. So 30% of the population at any given time is receiving psychotropic drugs. It's much higher actually among women, of course, at about 50%. We know that about a third of women also have diagnosis of PTSD. We also know that the prison environment, there's been over the years increase in self-injuries and suicide attempts, and those are, linked to psychological distress. I would say that in the past year, actually, because of COVID, we've seen an increased number of self-injuries as well as suicidal attempts, as well as an increase in use of force. So as a group, those who have mental health disorders, they don't fare well in terms of correctional outcome. They tend to be classified at higher security. They tend to seek refuge to administrative segregation, or what is now called the structured intervention units. They tend to be more involved in use of force, often because of some of their symptoms. And that's really unfortunate. Beyond mental health, there's certainly a great number of individuals in federal corrections with cognitive deficits. I won't go through the stats, but there are an inordinate amount of people with FASD, with intellectual impairments, with brain injuries, and learning disabilities, and all these makes the ability of those individuals to be successful in terms of securing their earlier parole release much more difficult, because correction has a great deal of difficulty providing services to those individuals. With respect to Indigenous in Canadian penitentiaries, it's something my office has done a tremendous amount of work. We are at a point where it's beyond a crisis. Over 31.5% of the federal inmate population of about 12,400 are from Indigenous descent. And that has been growing steadily for the last 30 years, and no government so far has been able to stop that trend, or even better, reverse that trend. Again, the correctional outcome for those Indigenous offenders are terrible. They tend to spend more time compared to in jail than non-Indigenous individuals. They tend to serve their time in higher in a higher security institution, maximum security, where there are fewer opportunities for programming, tend to be more subject to use of force, self-injury, suicide attempts, more likely to have their parole revoked or suspended. And they tend also to recidivate at an inordinate high numbers. So correction is having real challenges in terms of fulfilling its secondary duty of rehabilitation of those individuals. With respect to diversity in Canadian society, Black Canadians are also in general represented in the general population at a rate of about 3%, but in prison they are in federal corrections overrepresented, and right now it stands at little above 9%. So 3 times their rate of representation. So we've done lots of work on this as well, and we actually documented systemic discrimination against those offenders. We made lots of recommendations. Those recommendations in the work that we've done in 2013 were picked up and documented by the 2016 UN working group of experts on people of African descent. And unfortunately, despite all this sort of the correlation between my office recommendations and findings and the UN working group's findings, very few of those recommendations that we put forward have been accepted and worked on. There's also issues around addictions and substance abuse in federal corrections. In fact, about 75% of the inmate population have a history of substance abuse, and about over 60% were actually intoxicated at the time of their current index offense. So, you know, as you know, addiction and substance abuse can fall into a disability category and can be an actual mental health diagnosis. So in terms of socioeconomic and cultural rights, definitely there are some issues around education and employment. The average educational achievement of people being admitted to federal correction is about a grade 8 education. And in terms of employment, the level of skills is very low. And in fact, 62% of people who are admitted in federal corrections were actually unemployed at the time of their offense. With respect to women, there's been a significant growth in the number of women being admitted to federal corrections over the last decade. And we know that women, many of them are single mom with young children, and the majority of them actually. And we also know that women have been victimized in great numbers. And with respect to the Indigenous women, they are certainly been subject to sexual, physical, or psychological abuse at sometimes rates greater than 80%. So the overrepresentation of Indigenous women is of a particular concern. We are looking at about 42% of the women population is Indigenous, and a great number serve their sentences in secure units, which are the maximum security units in those facilities. I will leave you with one more on aging. Over the last 20 years or so, we've seen a growth in the number of aging and elderly offenders serving time in federal corrections. It used to be about 15% 20 years ago. We are now almost at 26%. And those offenders age 50 or more certainly do not receive the appropriate services that would be expected. And one of our systemic investigation done jointly with the Canadian Rights Commission found systemic barriers for that group. So it's just surprising that when you walk into some of those penitentiaries, you will see a great number of individuals that may have dementia, that may be wheelchair bound, that may be bedridden even, that may be dragging oxygen tanks, have a great deal of mobility restrictions, and it's just unfortunate that the service isn't being more proactive to transfer those individuals who pose very little risk and risk that can be easily managed in the community. So why the service isn't reorganizing itself to prioritize placement in the community of those individuals that, again, that could, many of them are palliative, some of them are even end-of-life, receiving end-of-life services in a penitentiary setting. It makes absolutely no sense. So I will leave it to that, and thank you, Monette. I'll leave it to the next speaker.
Great. Thank you very much, Ivan, for that incredibly thought-provoking and enlightening set of facts to provide us with a profile of the inmates in our federal prisons. So with that, I pass it over to you, Patricia.
Thank you. Ivan, when you were saying that, a lot of those, points that you were saying really, hit home for me, as you'll probably hear it in my story. I can't speak like free flow, so I'm definitely going to be reading it off today. First of all, I am grateful to be here and thank you for the opportunity and the invitation. As an Indigenous woman, I was criminalized not too long ago. It was in 2016. I was a Cape Bretoner living in Saskatoon. My very abusive marriage had just ended. My children were placed in care, and I was surrounding myself with people who were hurting like me. Mentally, I was probably at the worst of my life. Not being from Saskatchewan, having no family, no types of supports, I clung to anyone who showed me any kind of attention. I was also making terrible decisions and putting myself in situations that ultimately got me arrested. I was sent to Prince Albert Correctional Center for Women. I was placed on a gang range without any kind of proof I was affiliated with this gang, nor admitting I was. I spent 7 months locked in a cell for 23 hours a day. Looking back now, though, I think that was probably the easiest time of my whole sentence. I ended up pleading guilty with no Gladue report done, no Aboriginal social history, just to get it over with. I just desperately wanted to be with my children who were back in Nova Scotia. I started my federal time at Edmonton Institution for Women. The atmosphere there was a lot different than any other facility. This was my first offense of my entire life. I was 32 years old. I never had any types of fines or anything in my life. The relationships that you had there, it was probably like, you didn't have any kind of friendly relationship with the guards, definitely not your parole officer. There was a lot of violence, but I was quickly pen placed to Nova Institution in Truro, Nova Scotia. My flight home, thinking back now, was probably the worst, most degrading time of my whole jail sentence. First of all, in the total of 2 days we're flying, we flew with all different men and women inmates, all different security classifications. Men would be saying the most disgusting, vile things to us. They wouldn't care if they were getting in trouble at all or getting an institutional charge for it. Most of them were serving life sentences and were heading to max, and likely this would be the only contact with females they'd have in a while. And we're also shackled with a body belt and handcuffed the whole time we flew for the 2 days. At one point, I was praying for the plane just to crash. Thankfully didn't, and I finally made it back to the East Coast. Even as tired and dirty from not showering or a change of clothes for 2 days, I was relieved to be back home. Nova Institute was definitely a culture shock to me. Everyone was super nice. The guards referred to you by your first name. I've never experienced that out west. And I moved into the Aboriginal Healing House. And I soon met the elder who would change my life. I'm getting emotional just thinking about it. Sorry. Her name was Doreen Prosper. Doreen took someone who was so traumatized, had no self-respect, and hated themselves. And with teachings and traditions, she turned them into someone who started to heal. Every morning she smudged with myself and the other women in the house. We'd be put to work by piling wood for the next sweat, making the feast for the sweat, or taking the cedar off the trees for medicine. She taught us how to make prayer ties, and suddenly all these teachings started to become my day-to-day life. As much as I was starting to heal, I was also struggling in other ways. But I did eventually get my day parole in 2018, and I went to Sydney, Nova Scotia, to an all-white staffed halfway house, a white parole officer, and attended my parole mandated programs with a white program facilitator. As helpful as they tried to be, I still felt alone. I met a man and started a relationship that my parole officer didn't approve of. Since he had previous convictions, the thing that she didn't understand, and I tried to communicate to her, was at 33 years old, he was the first non-abusive relationship of my entire life. And I desperately wanted to be loved without being abused. So on Christmas night, I got breached for continuing the relationship and got sent back to Nova Institution. As sad as it is saying it today, I remember feeling like I was home. I had access to my elder, I had opportunities to sweat on a regular basis, and I had access to my traditional medicines that I didn't have those on the street. But I also remember the correctional manager saying to me, "Welcome back, Patricia, but why do you only hang out with Native girls? Is it your gang?" Until the elder had to step in and remind him, since time, Indigenous women always gathered, if it was for a sweat, to do their traditional crafts, or maybe just because they have shared trauma that a non-Native person just couldn't quite understand. But why in his mind would he assume that? That really does still bother me to this day. This time at Nova was so much more difficult than the first time. I was already struggling being away from my sons and my partner. I was lashing out. I had a poor emotions management, and the staff at Nova knew I was struggling. Besides the elder and the Aboriginal liaison officer, I had no supports. So I was like a power struggle there with the guards and management. There was a few situations where I witnessed some altercations and was questioned about what happened. And if you don't tell them what they want to hear or what they want to know, you're punished. So even though I stood beside my own personal beliefs and standards and had 0 institutional charges and I was a minimum security inmate, I was still placed in maximum security for a week while they did an override to make me medium. I'm still baffled how they can put someone in max on inmate generated information and no proof. So every time a report was being made, it went directly to the parole board and risked me to get my suspension lifted. What I don't understand is how can they do that with no proof? They don't even ask you about it. For instance, when I first got back, I was in a unit playing cards. Several guards came to get us to take us for a strip search and a urine test. I asked the guards over and over again, why are you doing this? Did we do something wrong? They stated it was just routine and random since I just got back. Until a week later, I got a copy of a report in my mailbox saying that they had gotten inmate generated information that we had drugs on us, is why they did the search. So why is it when I asked them the day over and over again, why didn't they tell me that? Why didn't they A, give me the chance to take responsibility for it, or B, rebut it and advocate for myself? How is it fair to just automatically put that in some paperwork, especially on inmate information who are not staff, who could be just someone who has a problem with you? All this paperwork ultimately did affect my release. I initially got denied to be released to the halfway house in Halifax. My elder came up with a great idea, though, about contacting the halfway house and to advocate for myself. Explain to them that I was a person behind all that paperwork, a person who had goals and wanted a pro-social life so badly, but was being denied that over hearsay and gossip. I did advocate for myself, and they did reverse their decision and accepted me. But I do help but wonder what happens to the women and the men, for that matter, who can't advocate for themselves. They just slip through the cracks, that's what. I got my suspension lifted in June 2019, once again, to a white parole officer. However, this time turned out to be one of the greatest supports of my journey. Not only was she completely culturally sensitive, I could be transparent and honest with her. I'm not ashamed to say today that she changed my view on parole officers, and I have nothing but respect for her. With her in the Mi'kmaq Friendship Center and the Elizabeth Fry, I not only succeeded with finishing my parole, but with also obtaining employment with the Elizabeth Fry Society as the first Indigenous peer support worker. I just also completed my first year at Mount St. Vincent University. I do believe I succeeded with all these supports. As I sit here today, I can't stress enough on the importance of relationships and supports. And those are the most important the minute that you do walk behind bars. The importance of having consistent access to your traditions and teachings, they're crucial to healing. And I'm sitting here today so grateful and honored to share some of my story and my truth. Willallen, thank you.
Thank you so much, Patricia, for your candor and for your courage.
Sorry for getting emotional.
That's fine, and for sharing your experience with us. Thank you. And with that, I'll turn it over to you, Tom.
Thanks, Monette. Hopefully my internet won't cut out again. So thanks first for inviting me to talk at this wonderful panel. It's just an honor to talk with Ivan, with Patricia, with Senator Pate, and with everyone else who's listening. I want to talk a little bit about something that I've been reporting on for a little while now. It's a reporting project that began almost 2 years, well, more than 2 years ago now. And it's something that touches, I think, both on the things that Ivan was talking about and on the direct experiences that Patricia has been describing. And that's risk assessment. It's something that goes right to the heart of the correctional process and is so crucial to how corrections operates and how the justice system generally operates, I think. But it's something that often goes under-examined or under-analyzed. So I'm going to talk a little bit about that and about some of our findings in our reporting, and perhaps, if I have enough time, where we go from here. So risk assessment in the correctional context has existed for more than 100 years now. It was the first, true correctional risk assessment was probably a tool developed in the 1920s by a Canadian-born sociologist at the University of Chicago named Ernest Burgess. He built a tool that was used by the Illinois Board of Paroles that would be used to determine whether someone was at high risk to reoffend, whether they were a good option for parole. And it's fascinating because, they used, I think he was looking at 20 odd variables, and some of those variables were, what kind of person is this person? Are they, and these are actual examples, a hobo, a drunkard, a farm boy, a ne'er-do-well. And, you can just imagine how things have evolved, but also you can see a little bit of the, those kinds of typologies exist even today in some of the risk tools that we use. But another question that was really important in that assessment was the race of the inmate's father, which I think is fascinating because that's a direct connection to a person's race right into their risk assessment. So, there's this kind of predetermination going on even back in the 1920s. So let's fast forward to today. My reporting project over the last couple of years has looked at the risk assessment tools used in Canadian corrections, especially at CSC, the Correctional Service of Canada. And I've learned a lot about the importance of these tools and the caveats and the pitfalls with these tools too. So I'm going to talk about 3 tools very briefly. These are the 3 that are among the most important that CSC uses. They're all developed internally, most of them in the 1980s or 1990s, though some came a little bit more recently or have since been updated. There's the custody rating scale, which is used to determine a person's initial classification. Will they be minimum, medium, or maximum? And we've heard a little bit from Patricia and Ivan about the importance of those decisions, right? They have enormous consequences for, where you're going to be placed, what kind of prison are you going to go to, right? Is it going to be a prison where you're locked in your cell 23 hours a day potentially? Or is it going to be a prison where you can cook your own meals, you can, walk around the grounds as you please, and all that kind of stuff. So that's the custody rating scale. We also have the static factors assessment and the dynamic factors identification and analysis. These are 2 tools that are used to make other determinations about a person, namely, what is their criminal history and what does their history tell, CSC and parole officers and potentially the parole board down the line about this person's risk to reoffend. And the dynamic factors test looks at their potential for change in the future. How much is this person capable of changing their innate behavior? And when you combine these 3 tools along with a few other tools that I didn't really get into in my reporting because there's so many of them, you learn a lot of very interesting things. You learn these patterns begin to emerge about the kinds of scores that people are receiving, especially once you control for things like the severity of their crime, the length of time they've been in prison, depending on the tool that you're looking at, and their criminal history, of course, their age, their gender, and most importantly, their race. If you control for all these factors, what I learned in my reporting is that, and this is looking at a massive data set of CSC scores, 750,000 rows of data going back, looking at 7 years for basically everyone logged in the Correctional Services database. What you find is that if you control for all those factors, Black men are roughly 24% more likely than white men to end up in maximum security at admission compared to white men, after controlling for offense severity, after controlling for criminal history, after controlling for age, all these confounding variables. For Indigenous men, they're roughly 30% more likely to be assigned a low reintegration potential score. And this is a score that, kind of says what it does on the tin, right? It's supposed to determine someone's odds of successfully reoffending. And you can either be a low, a medium, or a high. And while that score doesn't have as many direct, it's harder to trace a direct line to the impacts that it'll have on a person's incarceration. It does play a factor, especially at the parole board and when dealing with a parole officer, and in terms of the kinds of programming that you might be able to access, right? So Indigenous men 30% more likely than white men to end up with a low reintegration potential score at any point during their sentence. And both, as I found out, and talking specifically about men here to begin with, and both are actually less likely to reoffend than white men after controlling for the reintegration potential score, which means that, you know, they're receiving, they're actually reoffending at lower rates if you control for all of this stuff, which is fascinating to me. And of course, you know, in a follow-up piece, men are the large majority of the system, but women, as you know, Patricia and Ivan have explained, have their own, you know, the issues are often multiplied in those settings. And so in a later story that came out in December, I looked at the same patterns for women, and I found that the scores were even more misaligned between Indigenous and white women, which is, you know, quite shocking. Since then, my reporting has looked at, you know, the things that might play into this. One thing that came out in early January was that there had been a report published by Public Safety Canada, or not published, sorry, handed by Public Safety Canada to CSC in 2004, that's specifically written by 3 experts on risk assessment, 2 of which are internationally recognized as, you know, leaders in the field, of the kinds of people that get stopped at conferences and people want to buy them drinks because they're so famous. These 3 researchers looked at the CSC data on the custody rating scale. That is the most important tool that CSC has in its arsenal that determines where someone's going to go in terms of initial placement, minimum, medium, maximum, has all of these downstream effects in terms of treatment, access to jobs and programming while you're inside, and parole, of course. And what they found was that there were some serious questions about the custody rating scale as it existed then, and it hasn't been updated since. And in fact, in that report, which we published in January, they warned that there was the way that the risk tool is currently constructed left open an enormous door for systemic discrimination. And they warned, you know, you should really stop using this tool as soon as possible, or at least revise it. So you could put all this stuff together and you can see how risk scores are, we often talk about systemic discrimination and systemic racism in corrections as this, you know, much like as in policing, we talk about it in these abstract terms, and it seems so ineffable, so hard to grasp sometimes. What is, you know, creating these systems? What is reinforcing these systems? And I think risk assessments are a really good example of how you can bake these biases into these questions, be they subjective or not. Be it a question that says, you know, has this person had a criminal history, yes or no? And if it's a yes, it's 12 points. If it's a no, it's 0 points or whatever, versus, you know, something where a parole officer simply writes in an answer long form and decides what that level is going to be. It doesn't matter, because the way that these tools are designed allows for these, you know, ineffable, again, cultural biases to creep in. A perfect example is, you know, a question about a person's family background. If you ask about that, you're automatically, there's probably an implicit assumption that a person is expected to have, growing up, a father and a mother, but that's not going to be true for a lot of populations in Canada. That's not going to be true for a lot of Black populations. That's not going to be true for a lot of Indigenous communities, where for all sorts of complicated systemic reasons, that isn't necessarily happening. So that's, you know, some of our reporting on risk assessment. I hesitate to call it a series, but it's something that we're continuing to look at, and I'm hopeful to have more stories out in the future. But I wanted to talk in the 2 minutes that I have left here really quickly just about where we go from here. Something that I've heard discussed a lot by the experts that I've spoken with is this concept of individualization. In the same way that you want to have a sentence be individualized, you might want to have the risk assessments be individualized too, right? You don't want to have a one-size-fits-all approach to risk assessment. Measuring risk is probably important, right? But you don't want to have the same set of questions apply to everyone equally, even though that might seem fair on the surface, because as we know, there are all of these deeper differences, cultural differences, that you can't really control for in that easy way. One thing that's been discussed is the idea of building new tools that are from the ground up taking these differences into mind. And I know that sounds like a slippery slope, you know. One academic I spoke to once said, you know, if you do this, do you eventually build one for the Hungarian guy or what have you, right? Where does it end? But those are all questions that are worth asking, I think, especially if that process is undergone in good faith, right? What does individualization look like? How can you build a tool that is both flexible, but also, you know, rigid enough that you're not doing things 80 million different ways for every single person? And finally, I think that there's a really interesting question here about the access to this information about the justice system. The correctional system is often, you know, it's at the tail end of the process for most people, and it's something that doesn't get covered a lot by the media, something that doesn't get studied as much by academics. And, you know, with the exception of everyone who's watching this video, it's not something that people probably really think about that much. They think about the, you know, the police investigation, the court case, and then, okay, the person went to prison, we're done. We're not thinking about it anymore. But I think it's a really important thing to think about. And there's no better way in my mind than to make more information on this public, to increase the amount of transparency that exists around these tools and these processes. And, you know, perhaps we can have a discussion afterwards about what that looks like. But I think it's a really interesting question. And I'm just really, you know, interested to see where the discussion and the debate on risk assessment, on systemic discrimination goes from here in Canada. So thanks again. I'll mute myself now.
Thank you very much, Tom, for really shedding a light for us on very important examples of what systemic discrimination looks like and what does that mean, particularly in the correctional system. So with that, I'll hand it over to you, Senator Pate.
Great, thank you very much. And please, we've known each other too long, just call me Kim. I come to you from the unceded, unsurrendered territory of the Algonquin Anishinaabe, as are a number of the other panelists as well. And I want to thank the center, the commission, I should say, the International Commission on Jurists for organizing this, to you, Monette, and to David and to Errol for organizing as well, and to my co-panelists for all of their incredible work over many, many, many years. So when it comes to discrimination and corrections, I right away think we have two ways to come at this. We could talk about tinkering with the system, which is predominantly what has happened historically, or we could talk about fundamental rethinking of how we, if we truly want to address discrimination, how we do that. And I think we're in a moment, not just because of the health pandemic, the economic pandemic, but also the pandemic of racism that has been not just, well, I suppose discovered by some, but has been very much exposed during this past year and a half in a way that is undeniable for the deniers, if I can put it that way. And so I think we need to talk about, I'm really intrigued by Tom's mention. I've long felt that one of the strengths of working with individuals within the legal system, I don't call it a justice system, I'm hoping someday we'll get to that, but that one of the ways we can actually make change is one by one, tailoring our responses to the individuals we meet. And to a person doing that, we can make significant differences in the lives of individuals. But that is proverbial pulling people out of the water and not stopping the massive jet stream that is propelling the most marginalized, victimized, criminalized into into criminalization in our institutions. So I think we really have to, in addition to doing the individual work that so many people continue to do, and that has been really my life's focus for, you know, more than 40 years, I really think if we want to address this, we have to take on the systemic issues. And that means we have to breathe life into the Charter of Rights and Freedoms, particularly Section 15, which talks about equality, and the human rights provisions that Ivan spoke about, where we actually address the systemic inequalities, because our prisons are not full of wealthy white men. And that traditionally, the male, pale, stale institutions are the ones that have created the laws and reinforce the systemic biases that you've been talking about in this series. And so how do we do that? Well, I think we have to look at things like the economic disparity, the disparity in terms of ability, the racial disparity, the gender disparity, and address it. And there are ways we can do that. And again, this pandemic has brought to light the push for some of these needs. And so we could, with the kinds of resources that are currently going into criminalizing and imprisoning or otherwise institutionalizing the most marginalized, develop supports like pharmacare, dental care, health care, including mental health care, housing strategies, childcare, and have things like a guaranteed livable income, which we know those measures alone in jurisdictions where they've done it have reduced the number of people suffering with mental health issues, dealing with the economic deprivation that causes the, nearly 80% of the women and certainly high proportions of men are in prison who start with economic disparity, the trauma, the ability to actually have the trauma addressed that is historical, whether it's childhood trauma, trauma as adults, particularly when we talk about women, violence against women, to deal with the racism and the discrimination, the intersections that creates, and to deal with issues like the fact that we have increasing numbers of people with brain trauma now just starting to be discovered in prison. Many of us who've worked with battered women for many, many years long posited that. And we could actually address that while simultaneously addressing some of the issues that the others on the panel have raised. It goes back almost 30 years when, during the investigations into what was happening into women in prison, the Task Force on Federally Sentenced Women started promoting different ways of assessing women, for instance. Then we had the Arbor Commission. Then we had the Canadian Human Rights Commission report. And a study that I'm hoping Tom will include in one of his next series is the work, two things. One, the Canadian Association of Elizabeth Fry Societies, in response to the Arbor Commission, made a recommendation that instead of having risk assessments done in the way they did, recognizing that needs get translated into risk factors, I say for everybody, but particularly for women, particularly for young people, that's how we end up with 42 to 44% of women in federal prisons being Indigenous, 82% women are poor before they end up in prison, and the majority of them have histories of violence, and many of them have, as a result, anesthetizing addiction issues because of the lack of any other supports to deal with the trauma, as well as sometimes disabling mental health issues that develop. And so we need to also focus on those measures. So if we're going to address these issues and keep tinkering with the system, we need to acknowledge and accept. I'm not suggesting we do this, but we need to acknowledge and accept that we are accepting this trend is okay, that it's okay to continue to not just warehouse, but institutionalize and damage people who are already have the least advantage in our country. I don't think any one of us, nor anybody listening, would accept that. But that's essentially what we do when we talk about things like indigenizing the prison system, or encouraging, tinkering with the risk assessment tools. Instead of saying, fundamentally, why don't we start looking at decolonizing, looking at the TRC recommendations, the RCAP, Royal Commission on Aboriginal Peoples, the Missing and Murdered Indigenous Women and Girls Calls for Justice, decolonize, so that the supports that Patricia described she received from the elder, the tragedy and the travesty of that is not that she received those supports, that's fantastic, but that the indictment of our communities, that's not available to Patricia and others in the community first and foremost, that they don't end up in prison in the first place, they have contact with elders and ceremonies, is in prison. That's an atrocity, in my humble opinion. And that's in no way to denigrate or say anything negative about the supports received, but the fact that we accept that is problematic. And then we need to talk about decriminalizing and decarcerating. And decriminalizing, many of you will be interested that one of my colleagues, Senator Gwen Boniface, introduced a bill this session, to decriminalize drugs. Why? Because as the former head of the Ontario Provincial Police, who knows better how many people are dealing with opioid and other kinds of addictions who end up criminalized largely because of that. And Ivan gave some horrific but excellent statistics to back up why we need to move along these measures. Virtually every person worldwide but certainly in Canada, we don't do self-report studies anymore, I think, because the challenge to politicians and policymakers would be is strong when you hear that the majority of people, by the time they reach adulthood, have done things and continue to do things for which they could be criminalized if it was reported, if it was proceeded. And we know that it's certain people who come under, more likely to come under state gaze, whether it's because they're on the streets, whether it's because they're already monitored through child welfare, through social assistance, through racism and other kinds of discriminatory patterns we have. And that if we address those issues, that we could actually fundamentally change what happens. And we can look to countries like Portugal, where they decriminalized drugs and invested those resources into supports for people and have seen changes. We could also then decarcerate. When in 1992, when the Corrections and Conditional Release Act was introduced, one of this piece, it was billed as a piece of human rights legislation aimed at reducing the numbers of people in prison. And guess what? Racialized people were one of those groups. Women was another group. And in fact, we've seen those numbers escalate rather than decrease. And we saw with Bill C-83, the legislation brought in ostensibly to eliminate the use of segregation, actually also limited the use of those potential off-ramps out of the system. Section 29, which would allow people with mental health issues and other kind of health issues, elderly people, to be moved out of the system, was restricted. And in fact, there was more discussion about transferring people, lateral transfers within the prison system. Sections 81 and 84, which were set up specifically to help address the overrepresentation of Indigenous people, underrepresented. We just, ironically, during this pandemic, I have seen more examples of day parole other, i.e. people going home, not unnecessarily having to go to halfway houses or other, other community-based and less suppressive, but no less institutional types of approaches rather than going home. That was supposed to be part of the CCRA. So we could decolonize, decriminalize, and decarcerate at the same time as we're working on these substantive equality issues writ large for all people in this country that would benefit both reduce the numbers of people relying on healthcare systems, as well as social assistance schemes, as well as the prison system that gets used as the catch-all when every other system says no to someone. So what are some of the tools that have already been developed that we could look back to? So why did we introduce something about risk assessment at the Arbor Commission? Well, what we saw was the majority of women involved in the incidents that gave rise to the situation at the prison for women in Kingston. Oops, that's my timer telling me I have 1 minute, so I'll quickly. One of the things we saw is it was predominantly Indigenous women. Almost all of them identified as lesbian, and all of them had been in maximum security before they went to, before they were placed in that unit. So how did they end up there? Well, things that are really needs, deficiencies, if you will, or like lack of privilege, they became the way in which risk assessment was identified as higher for them. So we identified saying, well, if these are all their needs and you're translating them into risks, then instead of a risk assessment tool, let's focus on the needs. And the more needs someone has, the more resources go at, whether it's housing, education, all of the issues that we've talked about. Well, people thought we'd grown 3 heads, and that was the end of that. Then we had the Human Rights Commission acknowledge that all women were discriminated against in their 2000 well, they finished it in 2003, but it was issued in 2004. And as a result of that, corrections hired Dr. Moira Law. And have you ever heard of her report? Well, you may see it in the Human Rights Prisoners study, if and when we ever get that out from the Senate committee, because we actually talked about that, and so has Ivan. And she went around and looked and recommended that every single woman be started at minimum security, because in fact, that was the security level they were, and that only when there were incidents that gave rise to issues that would then increase their risk to public safety should they be increased. Well, guess what? She was supposed to be doing a 3-year contract. She disappeared after a year. You can all draw your own conclusions. So instead of continuing to tinker in this way, I think we have to, bite into this and say we are going to fundamentally change it. And we have opportunities. We have Bill C-22 is before the House of Commons right now. We could actually take Bill C-22 and insist that we incorporate the provisions that Erwin Kotler introduced a number of years ago, and that we have in a private bill, which is to allow judges the discretion to not impose mandatory minimums period. That will impact. The data that's coming from the Department of Justice and Public Safety right now is it is very clear. They have made assertions that Bill C-22 will reduce the numbers of Black and Indigenous prisoners, but they have no basis for that. They're just throwing up, well, there's a lot of them doing mandatory minimum penalties, but they can't show that it's just that penalty. And so the data is inconclusive at best, and I'm being kind now. And so we could fix that. We could also insist that there be judicial oversight of corrections in the way that the Senate amended or tried to amend, did amend, and then it was rejected by the government, Bill C-83, and to provide remedies so that where the treatment prisoners receive at the hands of corrections, and I use treatment in quotations, that if that is not what the judge intended, and let's face it, when judges sentence people, they're not thinking, I'm sending you to segregation, I'm sending you to maximum security, I'm sending you to be penalized worse and to come out worse than you went in. They're sending them thinking they're going to get support to address the issues that that cause them to be criminalized in the first place. That where that doesn't happen, there should be an ability to go back to court and have that sentence revisited. And if it's a life sentence, parole and eligibility or revisited as well. And so I think there are ways we could do this that fundamentally would change the way forward. And I think we need to have the courage to do it. Most governments now are afraid to do anything for fear of being seen soft on crime. I can't imagine now anywhere that people will accept that what we're seeing is actually addressing these issues and dealing with crime when crime rates are dropping, and yet the numbers of those most marginalized is increasing. So I've lots more, but I promised myself I would shut up now. So I look forward to the discussion and look forward to opportunities to, and if you want to ask me about some really, things that even blew my mind after 40 years and a couple of recent parole hearings, go ahead, Tom. It's about risk assessment.
Thank you very much, Kim, for such a great provision of a big picture for us all to look not only at a problem that is prevalent in the correctional system, but it's a reflection of issues of inequity in society in general. And how do we process the needs of people without having them do even more time and, as you said, come out worse than they were before they went in. And the money that's spent to do so is also incredible. I think that's something else we could talk about. So with that, there are a few questions that have come in, but perhaps, well, maybe I'll just pose one, and it's probably to you, Kim. And then we'll open it up for the panelists to have a free-flowing discussion. And somebody talked about, the use of the word criminalize. And we're not saying, obviously, that that person didn't commit a crime. So what does that mean, the word criminalize?
Well, it's interesting. When we first started using it at Elizabeth Fry, it was a function of, we used to talk about working with women in conflict with the law. And increasingly, laws have been coming in conflict with people. And so criminalize, recognize, it was a word that many have used, myself included, to recognize that it's increasingly your life and personal circumstances that are more likely to lead you to be criminalized than somebody else who may do the exact same behavior, but not to the same people. And the example I often use most recently is, everybody knows about the SNC-Lavalin situation, or maybe I'm dating myself because it's now a few years, but what was that all about? It's about creating deferred prosecution agreements for companies, for corporations. So a corporation can say, yes, I did this bad criminal thing, but look, this is how I'm going to make amends. And, so if I do this, would you actually get rid of that criminal charge? Like, how many individual people would that benefit if we did that with people? And one of the most litigated areas of criminal law is drunk driving. Why? Because people who have money and means get charged with it. And it's one of the few mandatory maybe I was saying the only, there may be one or two more, but right now I think it's still the only mandatory minimum, where if the Crown agrees that you go to treatment, you can avoid a mandatory minimum penalty. Well, guess who can go to treatment? What's the waiting list in most communities for treatment right now? It's a year minimum 6 months in some communities, but it's over a year. So guess who gets to go and avail themselves of that? The person who can buy treatment, can fund their own therapeutic intervention and avoid that sanction. So that's why we talk about criminalize, that it's more a function of your circumstances and your degree of marginalization rather than how much your behavior harms other people.
Great, thank you for that. So I'll open it up, panelists, to have a discussion as if you were in somebody's living room, and you know, what comes to mind, how do you want to challenge each other, how do you want to ask each other questions, and even agree with what you're each saying.
I can jump in here. One thing that came up in Kim's talk just now is, you know, this question of risk versus needs, and that's something that's come up a lot in my own reporting on this. And it's a really interesting question, because when you talk about risk, you're talking about, you know, how dangerous is this person to others? And when you talk about needs, you're talking about what does this person need to, you know, better themselves, to fix themselves, to put themselves on a path that'll get them to a place where they can be a happier person, perhaps a more productive person, but ultimately a person who is not in conflict with the law, as Kim's saying. And I think it's really interesting because they're kind of two sides of the same coin, right? You can think about risk as it's almost like to me, sometimes it almost feels like a punitive definition, and need feels a bit more like a restorative or a treatment-wise definition of something. Is it about what this person is going to do to others, or what can we do to this person to help them get there? And I think it's really interesting because one becomes the other, right? If you assign someone a low risk score, then they're going to have a much harder time accessing treatment programs, as Patricia probably experienced directly, as Ivan has seen tens of thousands of times, I'm sure. And it's a really interesting question, because you can see it play out every single day in all the people who are in maximum security. Those are people who are, by, you know, our own government definition, and I mean federally, provincially, whatever, because provinces have structures that are somewhat similar to this, not exactly the same, but you're putting someone in maximum and you're saying this person is, you know, very much not ready to leave the prison system. And yet they're the people that we're perhaps assigning the least amount of treatment to, which I think is really interesting. If anything, you know, one academic, Dr. Stephen Hart, I spoke with, said that if anything, it should be reversed. The people who get the worst risk scores should be the ones that get the most intensive treatment programs, the most attention from, you know, psychologists, from people who can teach them how to re-enter society, the most experience in terms of socializing normally with other people. And yet we do the exact opposite. I think it's a really interesting, conflict, and it leads to something that came up a lot in my reporting, which is this idea of risk scores as self-fulfilling prophecy. And I think you can say that of the prison system generally, right? You put someone in a low, in a bad risk score group, you put them in maximum security, and then, you know, you might hold them for a longer period of time. And when you eventually do release them, lo and behold, perhaps they reoffend. Is that really that much of a mystery at that point? It's a, you know, you can kind of draw the line back and see what led to that in some cases, which I think is a really interesting problem that I haven't seen discussed very much in academia or, you know, even on panels such as these, where we often talk about these things in very abstract kind of ways.
I thank you for that, Tom, because one of the things we tried to do, and Patricia's a wonderful example of that. When we developed after the human rights review, one of the things the women said as we were developing the data to submit to the Canadian Human Rights Commission was, we don't want another report, and you come in, you know, once a month or so, and what we need is the skills to actually be able to challenge this. Now, you know, if I could have put everybody in law school, I would have done that. So instead we developed the Human Rights in Action modules and manuals, and the peer advocacy work that that Patricia and many others continue across the country. And we didn't just go to the minimum security. We actually went into maximum security and said, you are all leaders. You're usually here because, you know, the perception of how you lead is perceived in a certain way by corrections, because if you're leading to challenge policies or to challenge the rules, then that's often not looked at very positively. Now, to a woman, the women who have been advocates, and Patricia, you may want to add to this, who have been advocates and then have taken those skills and gone out, may have been characterized as some of the worst of the worst. One was labeled a dangerous offender while she was inside. Outside has been, you know, like has just been blossoming. Yeah. And the example that that I was thinking of when I made the comment earlier about risk assessment, you know, one of the things just the last little while, a couple of parole hearings I've been involved with, women have been asked about the violence they experience. I was in a parole hearing with a man last week, and there was no question that there was an acceptance that the abusive home life he experienced, that was not questioned. It was treated completely differently than my experience of how women are treated when they talk about the violence they've experienced, even though the majority of the women in for violent offenses are there in large part reacting to the violence they have first experienced. It was mind-blowing to me. If I hadn't experienced it directly, I would have thought, you know, I must have glossed that over when I went from working with men to women, because I remember thinking, wow, they seem to be really hard on the women about their experiences of violence. And now it just got confirmed again in 2021 that that is still the situation, that a man who talks about the violence he's experienced, the fact that he would reveal that level of trauma, the presumption is he can't be lying about it. Whereas that man's mother, who I was also assisting, every person who's met with her has questioned how bad the violence must have been that she experienced. No question, the son, and he talks about, you know, the violence she's experienced and he experienced, and the whole family did, but the mother, it was not accepted. Then the other thing is, just recently, it may just be one institution, people have been asking, you know, if I get in the, you know, the risk assessment process and the penitentiary placement process, if I gave you a magic wand, what would you want to do with it? Well, the question, you know, what CSC wants every prisoner to respond is, oh, I would undo the bad thing I did, so I wouldn't have done the bad thing. Virtually everybody else, every judge, every other person who's not involved in corrections says, well, if I was a prisoner, I'd want to be free. Well, guess what? If you say that, your risk assessment goes up because your escape risk is seen as elevated, because if you had the chance, you're going to try and bolt. Hello, like, what kind of logic is that? I know Ivan, you know, I've already blasted on it, Ivan, about this, but the reality is, I agree, we have to look at those individual, but it's part of the systemic issue. And the challenge is that we just keep tinkering in this process, and we need to blow that up. And when you talk about the needs, that's exactly the recommendation we made to Louise Arbour, the commission, back in 1995 actually, and the report came out in 1996, that if you really want to address that's what Moira Law said should be done as well. But it's antithetical to a notion of prisoners as anything but quote unquote bad people. That if you're going to meet needs, then you're actually acknowledging these are human beings that we care about, that we want to be able to not just survive but thrive when they come back out of prison. And I think we have to name it, that it's a treating of people as though they're throwaway that is totally unacceptable. Sorry, I'll shut up now. Well, probably I won't, but.
If I can interrupt there too, like, you're so right there, Kim, because even when, you know, a woman goes into jail and, you know, with the 3 months of them doing the intake process, they ask you everything right from your childhood. So it's a rule there. You be careful what you tell them, because what you tell them, you're punished for. So even for me to tell them about my domestic violence and all the abusive relationships I got, then to them, relationships were a factor to me. So let me put on a parole condition where you have to report all your relationships with men directly to your parole officer. So it's almost like they punish you. So why would you want to be open and honest? It's super interesting for you to say about that, you know, man's parole hearing, because they don't treat women the same. we get scrutinized and then we get punished for being honest and open about it. And it's almost like, to be open and honest and being vulnerable like that, to speak about your past and all the pain that you've endured, and for them to use it against you like that, it's crazy.
So maybe I can jump in and try to respond a little bit on this notion of criminalizing. I've used the term certainly with respect to those who are mentally ill. I think there's lots of research that will show that over the years you've seen certainly a decrease in the number of psychiatric beds available in the community, a decrease in similar decrease in outpatient psychiatric care available in the community, and also things like services to those in need of affordable housing and issues like that, which often can alleviate issues. The other sort of concern that is well documented is this notion that many people with significant mental health issues cope by using various drugs or alcohol, and there is certainly a very high comorbidity. So because they're not getting the services, then they try to self-medicate, and then they get in conflict with the law. So I think there's definitely research that shows that as you decrease the number of psychiatric beds or outpatient services, you actually increase the inflow and admissions to jails, prisons, and penitentiaries, and that's why we have such high prevalence. With respect to risk assessment, I'll simply say that my office documented quite well that certainly, if we look at the women population in federal corrections, that the more restrictions you put, the more, if you want, acting out and problems you have. So this is why Kim has mentioned some of the innovative proposal by Professor Morai Law is a good one, because as I say, we've documented that if you, for example, with women who have psychological distress and self-injure, the more restriction and you place upon those women, then by escalating the restrictions and putting them in secure units, which are maximum secure units, or the sort of watered down version of administrative segregation that we have now, you will see more incidents of self-injuries. You will see also that the self-injury is much more violent, much more pronounced in nature. So I think to try to back down may be counterintuitive to correctional authorities, but I think that's the way to go. I think that most of our prison infrastructure is way more restrictive than it should be. We have 3 of our penitentiaries are over 100 years old, some of which have cells that are almost medieval, and I think there's a need for Canada to seriously look at getting rid of those older units in those old penitentiaries. Overall, our infrastructure is about 45 to 50 years old, tons of concrete, very little access to program area, very, certainly our maximum security penitentiaries that, as I say, are more than 40 years old, are not conducive to an environment that would properly support rehabilitation programming. So all to say that we should definitely, there's major reforms that are in need in federal corrections.
Thanks, Ivan. You know, listening to you all, and I can't help but think about, you know, the point that you're making about the system needs to be blown up, and we need a different correctional system that better supports rehabilitation. So, you know, I'm just interested about outcomes, you know, because we're looking at a system that has, as Tom has shown, and as we've all discussed, you know, systemic discrimination within it. If we were to start by one step, I'm just wondering if you can talk about the supports in the communities. Like, would that be one way to start to dismantle what we have? And if any of you can speak about the funding that's provided and the resources that are provided to keep people in prison versus what they get in community supports, because as we've heard from Patricia, she gets support to heal within the prison system that she didn't have outside. So it really makes people want to go back in to get the help that they need. And it, you know, what does that mean? So Ivan, I know that you've got some information about the funding, and for the rest of the panel as well, I'm opening it up.
Yeah, you know, Correctional Service Canada is, you know, it's a big business. It's overall budget of $2.5 billion, managing about 12,400 inmates and about, or prisoners, and about 9,000 men and women who are serving the remaining of their sentence in the community. They have, you know, one of the probably at this point is probably the highest ratio between staff and prisoners in the world. So the ratio is for 1 or now is actually one prisoner for a little more than 1 employees of the Correctional Service Canada. So which such high ratio, you've got to scratch your head that you should be able to do quite better. We spend on average over about $120,000 per year per prisoner in federal corrections. For women, it's closer to 200,000. And I'm very skeptical as that we can do better with that kind of resource in terms of correctional outcomes. For me, there are 4 different subpopulation that corrections could do its business differently. The first one are those who are seriously mentally ill or chronically self-harm or suicidal. I think those individuals should be transferred out of corrections because they're primarily patients. They're no longer so-called inmates. So I think that is one area that corrections could do better in terms of improving welfare and well-being and healthcare of those individuals. The other one are the Indigenous people. I think there's the correctional outcome while incarcerated in correctional facilities are terrible. So I think corrections should shift and reallocate a significant portion of its budget to provide alternatives that are community funded. So Section 81 and 84, which allow the Minister of Public Safety to enter into agreements with Indigenous community or groups for the care, custody, or supervision of Indigenous people. The third one that I think segment is the aging inmate population. So and I've talked about this for reasons that defy logic, it makes no sense to keep those individuals. The costs are phenomenal. They can be 2 to 4 times higher than those average that I've just mentioned to keep somebody aging and dying in prison. We have far too many natural deaths in prison, and I think it could be done by buying services again, and it would be much more in line with human dignity. And finally, the last group that I think we should really consider is, I think we should, at this point, really consider the closing of the secure units for women. I think this would be good progressive corrections and realization that the conditions of confinement in those units are excessively harsh. They are primarily housed with a majority of Indigenous women, and the level of services in those are just so inadequate. And there's got to be different and better ways. So I think the goal of the Correctional Service Canada should be to, over time, close those secure units. So that's it.
One thing I just wanted to offer, it's something that, just based on what Ivan was talking about, something that came up in conversations I had last year as I was reporting out that first story on risk assessment. And I'm not going to talk about risk assessment this time, I promise, was that I spoke to a member of the Federal Parole Officers Union. He's a VP, and he told me that, you know, in his view, given the amount of money that we spent per prisoner, per incarcerated person. So as Ivan was saying, $110,000, $120,000 per person, higher than that even for women specifically. There's, you know, it was his opinion that you could probably manage virtually all of those people in the community with very few exceptions. And those exceptions are the ones that everyone immediately thinks about, the names that get, you know, splashed across newspaper front pages every 5 or 10 years. But he made this interesting observation that, you know, if we want to talk about, you know, doing the crazy thing and we want to talk about decarceration, then the money is kind of there in a way. If you don't have to house those people anymore in a restrictive environment, if you don't have to have officers, you know, roaming the halls to make sure that everything's happening as it should, if you don't have to have all these stringent security measures, you free up a lot of money. And nowhere is this idea more prevalent in my mind than for incarcerated women specifically. I mean, we are, as a country, so close in some ways to decarcerating women. It would be, there's, you know, at any given time in secure units, there's probably under 100 women, right, Ivan? I don't know if that sounds about right. But there's only, you know, if we're looking at the population of incarcerated women across Canada federally, it's in the hundreds. It's not even in the thousands, I don't think, who are actively in custody, not in the community. So it's so close, you know, in some ways to being able to hit that target. And Ivan's suggestion of, you know, doing away with those maximum security facilities for women, which are just, you know, they're usually just buildings in this larger complex that have a few cells in them, right? It's a really tantalizing idea to me, and it's something that's come up a lot in my conversations. I'm sure Kim, Patricia have some thoughts on that too.
I definitely have some thoughts on that. I truly believe if they had 100 Holly houses across Canada, then there wouldn't be no need for prisons at all. But that's just me. I feel like all that money that goes into, you know, housing somebody, I don't know why it's so much more for a woman. Maybe Ivan could explain that, but I feel like supports and services and wraparound supports and services and creating that community for yourself when you get out with no expectations, like a little support goes a long way. Even like from my first parole officer, who was not culturally sensitive, who was, you know, I couldn't be transparent with, I couldn't be honest with, compared to the one I had in Halifax, made such a difference for me that just that one person, that one support. I remember when I first got accepted to university, she was the first person I called. I called her crying. Like, she was literally that big of a support. Even on my warrant expiry day, it was such a bittersweet moment for me. I said this to Monette because it was like, I was losing this support. It wasn't like I could be a friend with her. She, you know, was there to, you know, be my parole officer, made sure I, you know, completed everything, but I lost that. That was such a huge support for me. And then combined with, you know, EFRI, the Mi'kmaq Friendship Center, Mi'kmaq Legal Services, like, I just truly believe, like, for myself, even paperwork wise, like, if you've seen my paperwork, and, you know, Kim was saying it earlier, like the hardest people, the ones that are, you know, portrayed in paperwork as more or less a monster, are the ones that do the best when they're out, compared to somebody that, you know, isn't Native or African Nova Scotian and is just typically white. They're the ones, if you look at it, they're the ones that continue to go in and in and in. And then you got us, these monsters that do so well.
Don't call yourself that. You'll be having me on the phone with you if you keep that up, Patricia. No, I think it's wonderful to hear all of this. I mean, when a number of us first started talking about what we could be doing instead of putting money into prisons, there was a lot of people thought that was a little way out there. But don't forget that in the mid-90s, all the heads of corrections, all of whom were men, all of whom were white at the time, they, not people today doing defund the police or decarcerate and decolonize movements, they said that they could release up to 75% of the people then in prison and not increase risk to public safety. You can imagine what the numbers are now with an increased numbers of women, of racialized people, people with mental health. And so, you know, as Ivan has pointed out, as the parliamentary budget officer did in 2010 with the omnibus crime bill and costed out that you could put a whole bunch of prisoners through to Harvard education. So these would be international fee structures that you could house, clothe, feed, educate people for far less than what we're spending putting them in prison. And there's no end of money available seemingly to incarcerate. We don't have the same clinical assessment of how much, assiduous assessment of how much money is being spent to incarcerate people. And if any other system failed as horribly as our criminal, legal, and penal systems, you know, we would have a massive outcry. If you know, we're already hearing things like when the vaccines don't roll out fast enough, how quickly people are concerned. But again, I go back to, we have to ensure that we value people. I mean, the reality is if we put these resources into other means, and I know, Monette, you wanted me to speak about, you know, what jurisdiction is doing it right. Well, I think it's time for Canada to be the one to lead. We've had umpteen reports calling for things like wraparound services that Patricia talked about, from the ground up is the most recent one I'm familiar with. There's the creating choices, blueprint for change. There's every time we look at what should we do, we always come up with, you know, no matter who it is, the academics, the prisoners, everybody, when they actually look at how do we actually address this, they always come up with developing communities of support, ways for people to make money that isn't social assistance, punitive schemes, ways for people to be able to self-actualize, whether that's through working or volunteering or caring for people that they care about. And that we could be doing. And I think the pandemic has shown that we should be doing that, and that we should, instead of, as we're doing, you know, coming out of this system, economic recovery shouldn't, and GDP shouldn't be the only focus. We should be looking at well-being and human well-being indexes, and places like Finland, where when they got oil, at the same time as Alberta got oil, they decided to invest that money in their people. So any, you know, far off fjord in Finland, you can be educated and have health care. That's not what we did in Alberta, and they were roughly the same numbers when oil was discovered. So we know Scandinavian countries and countries where they invest more in human services, support services, they have lower crime rates, lower incarceration rates, lower recidivism rates. Well, let's build on that and do something even more so. So I like the idea of decarcerating all women to start with. I think we could decarcerate a whole lot of people. And when the law changed, the ICJ changed, the Youth Criminal Justice Act changed to require judges to have to put reasons about why they were putting kids in custody, the numbers of kids in custody was almost, not quite overnight, but within the space of almost about 18 months was cut in half. But the numbers that didn't go down, this is where it's instructive about why we have to invest in greater supports in the community. It was girls, and particularly Indigenous young women and girls. Those numbers didn't go down. So they are now 98% of girls in custody when I was working on a sentencing recently in Saskatchewan and in Nunavut and Northwest Territories. So, you know, when we know that, okay, then if you build more infrastructure around and you look at the sentencing provisions often referred to as the Gladue factors, I don't refer to them as that, but that's another story for another day. But if we looked at those provisions and said, let's focus on what people need to be in community, and then require judges to have to explain why they're putting them in custody. And, you know, lest you think this is the, you know, the ravings of, you know, weirdo senator now, I guess. No, not I guess, I know I'm a senator. But that, you know, when we started taking senators into the prisons, the exact, almost to the number of senators who insisted on the amendments to the Bill C-83 corresponded with the number of senators who had been going into the prisons. And that's not accidental, to draw on the point that Tom raised earlier in terms of, and Patricia, in terms of transparency, that when you see it, you can't unknow it. And once people went in, you know, they heard the glitz of the presentation by national headquarters and even by managers. They went into the prisons, met with people who were in prison and the staff working on the front lines, and got a very different picture of who's in prison, why they're in prison, and what we need to do. And I think that's part of it, as well as opening it up, that it's not just an abstract. I mean, what I'm saying may sound abstract. Believe me, it's rooted in the day-to-day grind. I mean, just during this call, I had to take a quick call for someone who's in crisis in one of the so-called structured intervention units in segregation. And, you know, those are realities every day that we need to address. And I think we have the means to do it. Certainly Canada has lots of financial, human, and resources that we could do this. And many people working within the system would be really happy doing other jobs that would provide better support. You know, and, you know, I laid out at the beginning some of the things we could be doing around income supports and that sort of thing as well.
Thanks very much. We've got 20 minutes left. I have one comment I'd like to share with the panel if you want to respond to it. It's not a question in particular. And also there's a request, Kim, for you. I think you teased the audience a little bit by saying, please ask me about, you know, what's the worst that I've seen in 40 years and give an example. So there's one person that would like that. So this is a comment I'd like to share. It says, not a question, but a comment. In my almost 50 years as a criminal defense counsel and a judge in criminal court, I was always conscious that sending someone to jail would just exacerbate the underlying problems that led to the person being in criminal court. Jail I viewed as an institution of higher education in criminality. The introduction of mandatory minimum sentences by the Harper government led me to leave the bench and start volunteering with a support group for ex-offenders. I don't know if somebody wants to comment on that.
Yeah, it's interesting because this kind of reflects something that came up in a story I did back in November, I want to say, or late October. I had when I was seeking comments to some of the findings that we published in our investigation on October 24th, I spoke with Kim's former colleague, Senator Murray Sinclair, and he said something really interesting, which was that, you know, his own experience of, and I'm sorry to talk about it again, risk assessment, but also, you know, other issues in corrections, both provincially and federally, was one of frustration, because he would, you know, in his sentences, he would look at the person in front of him and try to issue a sentence that was not only fair, but also, you know, in some way perhaps useful to the person being sentenced, right? Not to punish them, but to help them get their life on the right track. And so he would recommend things like, you know, I think this person should serve their time at this healing lodge if they can. I would like to see them seek out this kind of treatment, this kind of counseling, you know. And I've read sentencing decisions, and I'm sure Dr. Zinger has, Senator Pate has, Patricia has probably seen it firsthand, you know, where you have a judge say, here are things that I think this person should go through that I think would put them on a right path. And it's interesting to me because the system as it exists right now seems to take that power, and this is what former Senator Sinclair was saying, and takes it away from the judges the moment they enter the correctional system. The only thing that matters is that number. Is it 7 years? Is it 4? Is it 6 months, 2 days? Is it, you know, life with a parole and eligibility of 10 years, right? That's the only thing that actually ends up mattering. And I mean, I've seen it directly in the conversations I've had with former incarcerated people, with currently incarcerated people. One of the people that I spoke with at length was a guy called Nick Nushtai, who served 12 years in prison, almost all of it inside. He got statutory release at one point and had it revoked a few months later. And so he served until warrant expiry. 12 years for manslaughter. And his sentencing decision, the judge specifically says, I want this guy to serve his sentence at this healing lodge. And it's mentioned in all the CSC documents, but it doesn't seem like the healing lodge was ever contacted or if an effort was ever done to make that happen. And it's really interesting to me because we talk about corrections, but we have to think about it as the end of the spectrum of decisions that are happening in the system, right? And to me, one of the most fascinating things is that you have these people, these judges who are trained and who spend a whole lifetime thinking about ethics, fairness, morality, equity, and you're taking their decisions and really only like writing down the number at the end of the day. It's very interesting to me.
Maybe I can talk briefly with respect to the, I guess, the law and order provisions that were brought in by the Harper government. It's true for about a 10-year period, Canadians were flooded with an excessive number of new mandatory minimum penalties, some of which were deemed to be unconstitutional, and some of them are still in our books. I just have a little caveat, is that during that time, during those 10 years, every time that the Harper government actually put forward bills, law and order bills, that were basically increasing the sentences or imposing mandatory penalties or reducing the ability to receive parole or just harsher conditions of confinement. All those things, corrections capitalized to get more money because corrections was arguing that we will see a significant increase in the prison population. So during those Harper years, correction actually grew significantly by well over more than 3,000 correctional officers. And then what happened, strangely, is that in 2007, 2008, when we had an economic crisis, the government brought austerity measures. And what corrections did at that time is to protect the salary envelope and offer as cuts services to inmates. So that was part of the impact of those years. The prison population never actually increased significantly. It increased by about 10%, so about 1% a year, up to 15,000 inmates. So we never saw the massive incarceration that we were expected and that actually was speculated by corrections. So this brings me to the point that if we did not see an increase in prison population, a significant increase by having all those mandatory minimum penalties introduced, it is doubtful, at least at the federal level, that removing them will actually be the panacea and that we will see a significant reduction in admissions to penitentiaries. So I think that's a little bit of a caveat. Maybe in provincial jurisdictions, we might see more of an impact if we get rid of the mandatory minimum penalties. But certainly at the federal, I think it's doubtful that in it by itself will actually do very much with respect to the prison population. So just a little caveat on my, and the same thing can be said in my view with GLADU, which using more GLADU after GLADU was introduced in 1999, and the sentencing provisions was a few years ahead of that, so maybe 25 years ago, and we're supposed to reduce the overrepresentation of Indigenous people. Well, it didn't really work. We've been at it for over 20 years, a little bit more. I doubt that will actually yield significant gain. So I think that's why we need to do something a little bit more bold when it comes to reforming the correctional system and ensuring that Indigenous people are, if they are to be sent into custody, that the experience they receive is a positive one with good correctional outcomes.
I would agree with that assessment, but I think we also need to put in context that that's because we haven't addressed the racism and sexism and the other forms of discrimination that feed people into the system. And so very, you know, and I was really pleased to see the comment from, I figured out how to find the chat finally. Sorry, I'm a bit of a techno twit. And I see it was Felix who asked that question. Felix and Barbara, I don't know if Barbara's on as well, but you guys were an inspiration when I was at the Dalhousie Legal Aid Clinic as a student to really take on many of the issues in the way that I've had the privilege and responsibility of doing since then. So thank you for that comment. And I do think, though, that you know, we have to acknowledge that the rush to the right and the rush to create more punitive sentences started with the Liberal government, and this Liberal government in both iterations, as a majority and now as a minority, have really done nothing appreciable to address it. And the only difference I'd have with Ivan on this is I think if we don't tackle the mandatory minimum for life, I agree with you. But the mandatory minimum for life is actually what drives a lot of the women who have had to defend themselves and or their children against violence. That drives them into guilty pleas to manslaughter and drives the Crowns to offer those deals. I just had an amazing, phenomenal situation happen 2 weeks ago that, you know, if you'd have told me this would ever happen, I would have said, you know, I wouldn't believe you. A Crown, and I won't tell you even what jurisdiction because I'm sure that would not help the Crown. A Crown initiated a call to ask us to get some information to the Defense Council for fear that there was going to be an attempt to plea bargain a situation where a woman who had experienced violence and killed an abusive partner. Now, we'd been teaching at Ottawa U, defending battered women on trial since 2006. There's lots of Crowns that we've reached out to. There's lots of cases that have been intervened in, but there's more that have not been. And that is at the root of why I don't like calling Gladue factors as well, because the sexism and racism that she experienced meant that became a focus on a sentencing provision, not on the sexism and racism that refused to accept that she was defending herself and her sister who had just been raped by her partner. Instead, she was described as a jealous wife who stabbed her husband. Like, no, he was trying to get back into the place where he had raped her sister after he'd beat her up. That doesn't sound to me like anything but self-defense or defense of other, but that never got to the court. What got to the court was that the judge said, oh, Section 718(2)E doesn't apply because she may be Native, but she doesn't live on reserve, to use his words. And so, you know, we have to fundamentally undo those systemic biases that undergird all of this and really demand that we address those issues for, you know, in a bold way, absolutely, so that we don't perpetuate those biases and systemic barriers to actually providing these supports, and then free up those monies, provide them in the community. And I would guarantee you, and what I was going to say to answer the question of what shocked me was a woman who just 6 months ago, corrections was demanding spend 5 more years in prison and then go to a lateral institutional challenge or transfer into a long-term care home, because she's my age and they said she had dementia starting out. Because of the way they had described her, she's an Indigenous woman. She was the longest serving Indigenous prisoner at the time that she went. Because of the way they would described her, nobody would take her in the community. Nobody, nowhere. And so we argued that the impediment that they had created to her release was something that they had a responsibility to help undo. You know, the parole board, bless their cotton socks, they decided a day parole other was in order after we'd done, you know, an adjournment and a postponement. And just last week, I think it was last week or the week before, she got a recommendation for full parole, and she's been living with her sister. And even the people who initially recommended, to their credit, have now backpedaled and said how wrong they were. The very people who assessed that she needed to go from one institution, this woman has spent more time in SEG than any other woman prisoner in the country, and they wanted to transfer. Now they're saying she's barely recognizable to them. She's so happy. Gee, what a surprise. Her mental health has improved. Gee, what a surprise. Oh, she doesn't seem to have dementia anymore. Gee, what a surprise. And I can't tell you how many times that has happened, women that I've known, and I sometimes will be in the street with them, and people who were their correctional officers or guards don't even recognize the person that they may have spent anywhere up to 2, 5 or more years guarding. And so those are the realities that we have to, we have to keep challenging this. And that's why I'm so grateful for all the work, one, for you putting on this panel, for the work that Ivan does, for the work that Patricia does, the work that Tom does, because none of us achieves this alone. And it is moving the collective thinking in a way forward that I think will get us there. And we have the means. I think we're on the verge of having the will, and heaven knows if we can do it in Parliament, I'll be, cheering on everybody doing that. So I think, I take great heart in the fact that so many of my colleagues, just by going into the prisons and meeting with people, have a very different view of prisons and prisoners and what we should be doing about criminal legal reforms. So, as well as other social justice reforms and economic reforms.
Thank you so much. I think I'm going to begin to wrap it up, but before I do, Patricia, there's a couple of comments that were just for you, and in case you as well are having a hard time getting to the chat, I'm going to read those. So okay. First of all, thank you for your courage, vulnerability, generosity, and strength, Patricia. And another says, this has been an amazing panel. Thank you so much. A special thank you to Patricia for sharing your story. So I just wanted to
thank you so much. Monette, I was saying to you, I was so nervous because I'm with all these heavy hitters here today. So I hope I was okay, and I